I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
Okay, folks, today we have one of the most ignorant sovereign citizens I have ever encountered. How in the world are these folks still around in 2025? This man believes he can defend himself in court like a legal genius, despite the fact that he is illiterate. His principal contention? Since the prosecutor had 7 years of law school education and he had only an hour to understand the law, he argues that the trial is unfair. That would be like to going into a marathon unprepared, and whining that Olympic athletes had more time to prepare. Watching this will be both painful and entertaining. Please share your opinions in the comments section. Let's get started and watch how the law completely destroys this man.
The state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
As if he were a legal expert, this man, who can, hardly read, wants to stand in court and read his own motions. To be honest, how well do you think he reads? That's being polite. I'd probably say 6th grade. The truly insane part, though? He laments that he doesn't have enough time to learn the law. Is he truly under the impression that the judge will simply put his case on hold for years so he can pursue a legal education? The entitlement is absurd. You used to find someone who knew how to do something if you didn't, rather than throwing a fit and expecting everyone to take care of you. He has previously been offered options by the court. If you truly know what you're doing, you can represent yourself, hire a lawyer, or take a public defender. Obviously, he doesn't. What comes next? Will he request a postponement of his appointment to the Supreme Court? So far, how do you feel about this guy? Let's continue to observe.
For a waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on, and I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court, Michigan rules. And
does anyone else have the famous good speech, little guy, motion denied, ready to be thrown at him by the judge? For that's precisely where this is headed. It was really unnecessary for this man to read his motion aloud as if he were delivering the Gettysburg Address. I swear, it seems to me that the court merely allowed him to read it for the sake of amusement. Like, okay, let's all laugh. To be honest, it's probably the only reason she didn't stop him immediately. This is an excellent illustration of how judges have the authority to immediately reject absurd motions, particularly when they are squandering the court's time. The purpose of Rule 11 of the Federal Rules of Civil Procedure is to prevent such absurdities. People who file frivolous motions can be punished by the courts, and this one is undoubtedly pointless. However, perhaps he believes that if he speaks for a long enough period of time, the judge will magically accept his sovereign wisdom and dismiss the case altogether. That won't happen. Spoilers alert.
Also, People versus Lehman stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws to that. If we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this man truly this ignorant, or is he just acting that way? There's no way someone could be this absurd while facing real jail time, therefore I'm leaning toward acting. You can't just wing it and hope for the best, because this isn't your typical high school pop quiz. One single truth undermines his entire defense. He could have gotten a free court-appointed attorney. However, he spends everyone's time filing pointless motions rather than using the free legal assistance, and then he complains that he barely has an hour to study. Was he under the impression that this was an open book exam? He reminds me of that student in school who just started making things up and hoped no one noticed because he obviously didn't do any study for his presentation. Warning, everyone notices. Please let me know if you believe he is acting or if he is truly this lost. Let's get back into it.
It states that, and there's a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws stating and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22 when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez.
To be honest, the judge performed admirably in this case. Although we wouldn't have had such a nice chuckle at his expense, I believe she could have put an end to this guy a bit sooner. When he appeared in court today, what on earth was he thinking? He could hardly read that crumpled piece of paper he most likely found on the cell floor. So did he really think he could speak his way to victory? Knowing your rights is crucial for this reason, not to make up legalese, but to avoid looking like this guy and embarrassing yourself in front of a court who doesn't tolerate games. But in the end, judges don't put up with this kind of crap. Courts would not entertain your motion when you have free legal assistance right there, even though the judge was quite laid back and gave him some advice at the end. It simply doesn't make sense. I think this was one of the most ridiculous arguments I've ever heard. He is undoubtedly a living example of how not to behave in a court of law. You cannot make up the rules as you go along, since the law is not a choose-your-own adventure book. At least this guy provided us with some good entertainment, though. Anyway, this is where I'll end it. Tell me what you guys thought of this person. He was your average sovereign citizen, and if I'm being generous, I'd estimate his reading proficiency to